Lucio Ramirez, correct?
That's correct, Judge.
And let's see, Mr. Payne, you were served with this lawsuit while you were in jail back on, what was the date of the service?
Judge, I'm showing it was August 7th, 2020.
Yeah, there it is, August 7th, 2020. So that was not quite a year ago. Do you remember getting served in the jail?
Yes, Your Honor.
Okay. And then what happened was you have under the law so many days to file your answer. And apparently as of yesterday, there was no filing of an answer. So you never filed an answer to this lawsuit, right?
Negative, Your Honor. I did have 2 attempts of trying to actually send a filed answer with this lawsuit. Being that I was incarcerated, it made it a bit harder to do it than just normally. I did contact legal aid. They were trying to help me. Unfortunately, I was denied legal aid for the civil lawsuit because they said I have this same case in a criminal lawsuit. And when at the time, my attorney for the criminal lawsuit had told me, do not worry about the civil lawsuit. They are not going to do anything until the criminal lawsuit is done, since it is the exact same case in criminal court. And I was like, okay, now that attorney is no longer practicing private law. He's now part of the district attorney's office. So as I was given a new attorney, my new attorney advised me otherwise, which is why I had started pushing in the manner to try to get in front of this in the civil matter. Again, I wasn't aware that you can be held in 2 different courts for the same case on civil and criminal. Once I was informed by my attorney that I can be, that is why now I'm starting to proceed, quote unquote, turn the wheels on this, Your Honor. You have a criminal case also pending in my court? No, not in your court, Your Honor. I'm in the CC4 with this plaintiff. Mr. Lucio Ramirez has not only filed a civil lawsuit, but he's also filed criminal charges against me. At this point right now, we're set for trial at a future date. From my understanding, we're looking at August 26th. However, they've given me multiple plea agreements, which I have not agreed to. I'm taking it to trial as well. And that's where we're at in the criminal case.
But as it stands on the record, you have not filed an answer to this civil lawsuit, correct?
No, sir. I was also served with a notice of a default judgment. I did contact the court. I was unable to successfully contact somebody, but I did contact because I did wish to be present for it, which was, I believe, I received the notice for default judgment under Rule 239A. I received it on the 25th of April. So within the time that I tried to, I did finally make contact. I left a voicemail with the court coordinator that I wish to be present. I wasn't called for it. And now I called again because I was going to file a motion to set aside default judgment and also a notice of hearing, Your Honor. But it's just very difficult to do all these things from the jail, especially with the law library not being full accessible by us inmates due to the COVID pandemic, and also them using it for court purposes and other reasons, Your Honor.
All right. Well, when I heard all of that, I said, that's fine. We'll do the default hearing with you present. So, Mr. Sprouse, will you present? You can present your evidence in support of your default judgment.
Thank you, Your Honor. Plaintiff's motion for default judgment is supported by, excuse me, Judge, lost my place. Certificate of last known address for each defendant. That's exhibits A1 and A2. An unsworn declaration in support of defendant Payne's military status. That's exhibit B2. An unsworn declaration in support of plaintiff's request for attorney's fees. That's exhibit C. And of course, the exhibits D1 and D2 are the return citations for each defendant showing that they were served. The returns have been on file more than 10 days prior to the filing of the motion for default judgment. There's been no answer filed by either defendant. Plaintiff stands on the allegations that were made in its original petition and asks the court for the entry of a default judgment in the principal amount of $29,607.28, reasonable attorney's fees of $2,750, conditional attorney's fees of $3,750 at the two appellate levels, Court of Appeals and the Supreme Court of Texas, plus court costs and expenses, all taxable court costs and expenses, and post-judgment interest at the judgment rate of 5%. Thank you, Your Honor.
All right. So your response then, Mr. Lawrence?
Your Honor, at this time,
Payne, pardon me.
yes, sir.
Yes, I said Lawrence. Your last name is Payne.
Yes, my name is Sean Lawrence Payne, Your Honor.
Okay, your response, Mr. Payne.
In response to this, Your Honor, I wish to take this to an actual trial where I can present factual evidence that shows this is not true and correct, Your Honor. The allegations that are being brought upon me stand. I cannot share a lot of information until I do speak with my criminal attorney on this. There is a few things that will be presented in my criminal case that pertain directly to this, that my attorney is working with the DA and the courts in regards to all this, Your Honor. So unfortunately, my attorney is on vacation. He's been on vacation. He will not be back to the 22nd. In order to disclose those, I wanted to make sure with him. I just haven't been able to get a hold of him, Your Honor.
Who is your attorney?
My attorney for my criminal case is they just gave him to me a few weeks ago, Your Honor. Jerry McLean. That's McLain.
Your Honor, I would just note that in the original petition, in the factual background section, paragraphs 8 through 13, plaintiff pled its case in great detail, including dates, damage figures, and there was no answer filed by either defendant. So the factual allegations in the petition were very detailed, and they support, in light of the default that was taken, or the failure to answer, they support plaintiff's motion for default judgment. And I believe the court's plenary power over this case has expired. The judgments were taken on May 3rd against both defendants, and more than 30 days have passed without an appeal or a motion for new trial being filed.
Your Honor, if I may, I was not given this notice until the 6th or 7th of May. Be that I am incarcerated, even though the attorney, Mr. Spoils, may have sent everything to the court and everything may have been done in perfect timing on his end, Your Honor. When it gets to the jail, it is not immediately given to us inmates. It takes a process it can be up to a week before I actually receive it, Your Honor. I didn't receive any of this notice recently until May 7th here at the jail annex. Once I did contact the court coordinator and I made her aware that I received the notice and I did wish to be present during this, Your Honor. I was told that it was going to be yesterday at 10 a.m. and I didn't hear nothing. I do not have the liberty, Your Honor, to be able to exercise the right, the way I need to be able to defend myself in this case, Your Honor. I do wish to hire an attorney. I'm supposed to be being released from the jail here coming up within the next few weeks, Your Honor. Then I do wish to hire an attorney. I am not a lawyer. By no chance do I wish to act as my own attorney on this, Your Honor. I've only had a few moments to briefly look at a very, very minimal amount of law and understanding in what's going on. I reached out to legal aid. They originally had accepted me, but when they realized I was in custody, they denied being able to represent me in this case. And they were the ones who informed me of the bit of rights that I do have to be present and to request a motion to set aside default judgment, Your Honor, which I did have those motions here. But when I spoke to the clerk, she told me I'm going to go ahead and reset it and you could speak with everybody then. And that's what we're doing here today, Your Honor. All I ask is that the court give me a reasonable chance, Your Honor, to defend me, to defend myself.
Well, what's happened is what I already issued the default judgment. When?
May the 3rd.
All right. Well, what has happened is I can't go back and hear that default hearing at this time because I don't have jurisdiction to do it. It's been over 30 days. However, you were on the right track of getting your lawyer to file a motion to set aside the default hearing, so the default judgment. Now, there are ways to attack the judgment. Like you said, when you get out in a couple of weeks, you can get your attorney, as you said you were going to, and then they can file the appropriate motions. If you don't get an attorney, you can do that yourself. But you know, as it stands, I can't set it aside today because, you know, I don't have jurisdiction to redo the case. And there's no motion before me that would require me to do that or even request me to do that.
Okay, Your Honor, that's understood. I do appreciate the court's time and everybody's time, Your Honor. And this time I would like to go ahead and excuse myself if we're done.
Yes, we are. And thank you. And hopefully you'll get the other parts of it taken care of soon.
Thank you, Your Honor. I appreciate it.
All right. Thank you. All right. Thank you, Mr. Sprouse.
Thank you, Judge. Have a good day.
You too. All right. Let's see. Now let's move on to criminal matters. Let's see. Okay, the first one I had was Ricardo Alfaro.
Yes, sir.
And that is a bond hearing.
Yes, Judge.
Okay, these are, okay. You're Mr. Ricardo Alfaro,
Yes, sir.
and you recognize your attorney, Ms. Pages, here?
Yes, sir.
And, and let's see, Ms. Ritchie, are you representing the state in this matter?
Yes, Judge. Sorry, I thought my camera was on.
Okay. Let's see, 3 different cases here. 2020-3491, 2020-6462, and 2020-4203. But has the defendant made bond on some of these cases?
Judge, I only have 2 cases.
Oh, okay.
I don't have,
3. Which one of those that I called do you not have?
well, I can tell you the ones I do have, 3491 and 1385, Judge.
3491 and what?
1385?
Well, I don't have a 1385. What does that charge?
It's an aggravated robbery, Judge. He only has 2 charges, Judge. I'm not sure.
What are these others? 2020-0D06462.
I don't have that one, Judge, either.
I don't think that's him, Judge.
Okay. And the 2020 4203, that's not him either?
No, I don't know who that is.
Okay, but then you do have 2020
Oh, I'll let her.
zero. What's the ag robbery?
Morning one today though.
Yes, Judge, the ag robbery ends in 1385. It's 2021. And the last four at 1385.
Judge, in the 2020-6462, it is a Miguel Eduardo Alfaro. Different birth date, looks like a different individual. So,
Okay, so the ones that are in front of me today is cause 2020 0D03491, right?
Yes,
A possession of narcotics charge between 1 and 4 grams. And then what's the number of the other one? 2020 0D0 what?
it's 2021 0D0 1385.
And that's the aggravated robbery charge?
Yes,
Okay, now we're on track. Did he make bond on the narcotics charge?
no, Judge, the bond for that one is a 50,000 cash surety. And the bond on the ag rob is also 50,000 cash surety. And I am requesting that they are reduced, that each one is reduced to 15,000 cash surety with PR. However, we might be able to work something out, Judge. I've been in communication with Ms. Ritchie, but I'd still like to proffer some information to the court if that's okay.
Okay. Right, go ahead and present the evidence that you would like me to hear regarding your client.
Yes, Your Honor, thank you. So my client, Mr. Alfaro, is 27 years old, Your Honor. He is from El Paso, Texas. He has been in custody for 41 days and he has not been able to make those bonds, Judge. They are too high for him and his family. He has 2 little boys, Your Honor, ages 11 and 7. He does pay child support for the 11-year-old when he is employed. And he does help to support his 7-year-old child. He does have a relationship with both of his children. If Your Honor were to reduce his bonds, Judge, he would have employment ready to go at International Wire as a punch operator, and he would be working a 12-hour work shift, and it would be full-time, which is good for his children so that he can help to support them. He would also be able to reside with his parents, Judge. His parents are Martin Alfaro and Elena Alfaro, and I am in constant communication with them. And he would be residing with them. He would also, Your Honor, be willing to participate in drug counseling to address any substance abuse issues. And Judge, just so the court is aware, on the aggravated robbery charge, I have tendered to Ms. Ritchie a non-prosecution statement. And Ms. Ritchie is in the process of getting in contact with the complainant. And it's my understanding that this charge might go away, depending on what Ms. Ritchie discovers with the complainant. And we might be able to work something out on this possession case. And I know that Ms. Ritchie is asking the court to reserve your judgment until at least Monday to give her some time to communicate with the complainant. And I'm okay with that, Judge.
Okay, what allegedly happened in that aggravated robbery?
Well, Judge, this occurred on April 25th of this year at around 7 p.m. On Gateway East. I believe it was a gas station. This was a delayed report. I believe she didn't report it until the next day, but the defendant and the complainant are or were friends at the time. He showed up to her house and asked for a ride to a gas station. And while at the gas station, he told her to get out of the car. She thought he was joking around, and that's when he pulled out a medium-sized kitchen knife, put it up against her chest. She freaked out. He took the car keys out of the ignition and took her backpack with her wallet and some cash and debit cards. and then left. And then I think he called her at one point a few minutes after he left, stating that he was going to come back for her because he wasn't done yet.
Right. And what's the drug case about?
Let me pull that one up, Judge. This was a part of a human trafficking investigation with DPS. They had seen a vehicle dropping off multiple people at a residence. They believed that there were illegal aliens in the vehicle. There was a traffic stop for speeding. And I believe he was the driver of the vehicle. And at one point he said that he had a meth pipe in his jean pocket. He also admitted to having some meth in his truck. And that is when the officer retrieved a crystal baggie inside of his jean pocket and the meth pipe. And I believe it was about 1.6 grams gross aggregate weight.
Okay, and what's his criminal history?
He doesn't have much. I think he had a previous ag assault that he received 3 years probation for. It looked like that was successful, and then that was in 2013. And then a 2016 possession of marijuana under 2 ounces, 3 days jail, and a 2012 interference with emergency call that resulted in probation as well.
What did they do on that? I note here there was a federal case on human trafficking possible. Was that based on what was going on there at the place where he stopped?
Let me see where the
They're gonna charge. Do you have any idea if they're going to charge him federally on that?
No, Judge, I don't think there was any information on that. I don't think he has any ties to that, Judge. And I didn't see anything in the report that would indicate that he has anything pending.
Okay. I also show here on my card back in October 19th of 2020, I surrendered his PR status, I think, on the drug case because he had failed to report.
Yes, Judge, that is correct. He had failed to report on PR bond, and he understands that, Judge. He has been in custody for 41 days, so he knows that if his failure to report will result in him being in custody, so he is aware of that. Which is why I'm asking for a split, Judge, on that issue. And like I've indicated, Your Honor, he is willing to address any substance abuse issues as well.
All right, Ms. Ritchie, your position on these bonds? I mean, do you
Judge,
think 15,000 cash or surety on each one is sufficient or not?
I don't think it's unreasonable, but before I do make that judgment, I do want to speak with the victim and make sure that that really is a decision that she wants to make, that she doesn't want to press charges, that she didn't feel threatened in any way. I'm also in the process of looking at jail calls to make sure that there's no issues there as well. But I think if it was just kind of a misunderstanding between them or something, I feel like 15,000 would be sufficient. But I would like that time to confirm that with her.
All right, you think maybe by next Tuesday, you should have all that information?
Yes, sir.
All right, well, let's meet again on this case on next Tuesday. And I'll make my decision then.
Okay, thank you, Your Honor.
Thank you. All right.
Right, sir.
Let's see. The next case is. I'll do that one last. We have Jose Ruben Estrada.
Yes, Judge. So I believe I did receive a rec. I just want to make sure that it's a new rec. And if I can just be placed in a breakout room with Mr. Estrada to convey that to him, and we might not need the bond hearing.
Okay. Can we do that? Okay, we'll let you do that.
Lexa, so it's 1244A, right?
Yes, ma'am.
Okay.
What was the rec there now?
1244A time served, Judge?
Oh. Did they get to go and talk in that room?
I'm not sure, Judge. It's not letting me close it out, so I can't tell. I don't see Miss Pages on here. I still see, oh, there Miss Pages is. You're on mute.
I was in the breakout room by myself.
Okay. Does the annex need to push something on the computer in order for him to go into the breakout room?
You know, I don't see anything, ma'am. Okay, I see it.